Okay, let's unpack this. Picture, a totally normal place. A shopping center car park in Sydney. Seems ordinary, right?
Yeah, completely mundane.
But then something terrifying happens. Yeah. Something that doesn't just lead to charges, but kicks off this massive legal fight. And it asks this really fundamental question about our whole justice system.
Hmm.
Can you actually opt out of a jury trial because you're afraid they'll be biased against you?
That's exactly it. That's the absolute core of this case. You've got this tension between one person's fear, and it's tied up with his culture, his religion, and then this centuries-old tradition we have of trial by jury, your peers.
And our mission today, and this is tailored just for you listening, is to really dive deep into the Abdul Belghar case. We're going to walk through the pretty dramatic events that started it all. Then the really complex court battle over whether he should face a judge alone. And crucially, how the final decision in this case actually reshaped how judge-alone trials work here in Australia. This was like way bigger than just one guy's trial.
Absolutely. It ended up setting new rules, basically. We're drawing on the sources you've got there, guiding you through all the twists and turns, the main players involved, and just making sure you really grasp what matters in this fascinating legal story.
Right. Let's start with the alleged incident itself, because that's kind of the overture, isn't it? The spark for the whole legal drama.
Yeah, the legal fight was all about procedure, Section 132 of the Criminal Procedure Act, judge-alone trials. But it all started with a really violent incident. Broadway Shopping Center, December 2009.
But the legal significance, as you said, it just exploded from there because it became the test case, really, for challenging the NSW laws on judge-alone trials.
And that incident and the fear it generated in Belghar, it immediately highlighted that fundamental clash, didn't it? An accused person's right to a fair trial versus, well, the community's interest and maybe historical preference for juries, especially for really serious stuff.
Okay, so like any good story, we need our cast of characters, our dramatis personae, if you like.
Yeah.
At the very center, obviously, is Abdul Belghar, the accused. The sources tell us he was the brother-in-law of the complainant, Kanan Cockton. He'd been married to her older sister for, 11 years?
That's right. And the prosecution's whole theory, their alleged motive for him, hinged on this idea that Belghar held quite conservative Muslim beliefs, and that the whole thing blew up because he was furious that his sister-in-law, Kanan, had supposedly taken his wife to the beach.
And it was that alleged motive tied directly to his faith background that became the bedrock of his argument later for wanting a judge-alone trial. He said he was afraid a jury would be prejudiced. Because of those beliefs, and also because of, negative press he saw around people with similar beliefs.
Yeah, and the sources mentioned some subjective things, too, that came out later, maybe at sentencing. He was 37 then, born in Morocco, apparently suffered from long-term anxiety, depression, social phobia, was even on a disability support pension.
So these personal details, particularly his cultural background and his mental health, they became really central to why he argued he couldn't get a fair shake from a jury.
Then you have Kanan Cockton, the complainant, the alleged victim. She was 22 around the time of that beach incident. Her story was, the dramatic heart of the prosecution's case.
Her account was pretty terrifying, wasn't it? Threats, being slapped, being lifted up, and held over a railing way high up, crying, thinking she was actually going to die.
Yeah, absolutely harrowing. Then, of course, the judiciary, several judges played key roles.
First up in the district court was Judge Solomon. He was the one who initially granted the judge-alone application, said yes, though, interestingly, the higher court later described his reasons as informal and shortly stated. Doesn't sound like a ringing endorsement.
No, not really. Then, when the Crown appealed that decision up to the NSW Court of Criminal Appeal, the NSW-CCA, the main judgment came from Chief Judge at Common Law McClellan. His decision was comprehensive, really dug into the principles of Section 132, setting the framework we still use today.
And there were two other judges on that appeal panel, Hidden and Hislop. They agreed with McClellan on the outcome overturning Solomon's order, but they had slightly more reserved views on some of the broader principles. Adds a bit of nuance, shows the law was still being actively shaped,
Definitely. It shows that internal judicial dynamic. And finally, after all the appeals about the trial mode were done and Belghar eventually pleaded guilty to lesser charges, Judge Zara handled the sentencing back in the district court.
Right. And let's not forget the lawyers slugging it out. For that main fight over the judge-alone trial, both when Judge Solomon heard it and then in the big appeal, R.V. Belghar NSW-CCA 86, the legal teams were actually consistent, weren't they?
They were. Representing the Crown, who were arguing against the judge-alone trial, you had counsel N. Noman and N.J. Gouda. They were instructed by the solicitor for public prosecutions.
And fighting for the judge-alone trial for Ismail Belghar was counsel G.A. Newton, instructed by the Legal Aid Commission of NSW. So these two teams faced off on this really crucial procedural question.
Then later, much later, when Belghar appealed his actual sentence, a separate appeal called Belghar v. NSWCCA 245, the teams changed, which happens a lot in these long cases.
Yeah, makes sense. On that sentence appeal, Belghar's team was counsel Aziz Francis with MSC Wasley, again from Legal Aid NSW.
And the Crown, responding to that appeal, was represented by counsel N.S. Herbert, instructed by S. Kavanaugh from the ODPP, the Solicitor for Public Prosecutions.
Okay, got it. So let's rewind back to the beginning. Act I, the spark at Broadway. The incident itself was dramatic, sure, but the sources suggest it didn't just happen in a vacuum. There was this earlier event about 2 months before.
That's right. It seems to have set the stage. It involved Kanan Cockton, her sister Hanif, who was Belghar's wife, and a friend going to the beach. When Belghar found out, his alleged reaction was extreme. A furious phone call to Kanan.
And the alleged threats were chilling. You slut, I'm going to kill you, I'm going to fuck you up, how dare you take my wife to the beach. Just horrific stuff.
And Hanif, his wife, apparently told police he was very angry. He mistakenly thought she'd worn a bikini, which she denied, and he apparently just didn't like her sister Kanan. This whole thing led to Kanan actively trying to avoid Belghar afterwards.
Understandably. Which then leads us to that evening, December 22nd, 2009, Broadway Shopping Center. Kanan shows up with her brother, Octay, and his kids, his daughters. She spots Belghar and Hanif, tries to steer clear, waits outside on a walkway railing.
And this is where the Crown says things went from bad to potentially deadly, very fast. Belghar allegedly walks away from his wife and brother-in-law, then turns, comes quickly towards Kanan. He's got a key in his hand, gets close.
And repeats those alleged threats. I'm going to kill you. I'm going to fucking kill you. Then slaps her across the face.
Then the prosecution alleges the most terrifying part. He supposedly lifts Kanan up, carries her about 1.5 meters, maybe 5 feet or so, over to the external car park railing, and holds her horizontally over the edge.
It was a 12-meter drop, wasn't it? Like 4 stories down.
Yeah.
Her upper body facing the ground.
Exactly. Kanan's account, as you said, just pure terror, crying uncontrollably, certain she was about to fall, about to die. And later, her sunglasses were found down on the roadway below, a kind of silent witness to what happened up there.
But thankfully, her brother Octay reacted.
Instantly. Tackled Belghar, freed Kanan. She fell back onto the walkway floor, then just ran, obviously distressed. Belghar allegedly left.
But Belghar's version later that night to his wife was very different. He reportedly said something like, I went and said to her, stay off my back, please, and she gave me that attitude and it made me angry.
And his police interview, a completely different story again. Denied any assault, claimed he only picked her up because she was losing her balance while yelling at him, and he was afraid she'd fall and get hurt. Denied any intent to harm her at all.
So you have this incredibly stark contrast, don't you? This stark dichotomy, as the courts might say. Kanan's terrifying account versus Belghar's denial, and his claim he was actually trying to prevent her falling.
Absolutely. And figuring out who was telling the truth, what Belghar's real intent was, that became the absolute crunch issue. Which is exactly why the question of who should decide that a judge or a jury became so critical. It directly linked the alleged crime and motive to the whole procedural battle that followed.
Right. So with these really serious charges on the table, attempted murder included the focus shifts. From the car park walkway to the courtroom, Act 2. The battle for the bench begins. How would Belghar actually be tried?
And his legal team went for it. They applied for a judge-alone trial under Section 132 of the Criminal Procedure Act. Now, this section was crucial because it had been changed back in 2011. Before that, the prosecution could pretty much just say no to a judge-alone trial. The amendment removed that veto.
So the door was open, at least in theory, if the court decided it was in the interests of justice.
But the first attempt hit a snag, a procedural one. Belghar's team put in the application, this was September 2011. The formal charges, the indictment had been filed earlier, but then it was amended. They applied before he'd been formally arraigned on that amended indictment.
And the district court initially refused the application.
Refused it. Belghar appealed that refusal to the NSWCCA, but the appeal court said, nope, dismissed. Why? Purely technical. The district court didn't even have the power, the jurisdiction, to hear the application properly at that stage because he hadn't pleaded to the right set of charges yet.
Ouch. It shows how precise criminal procedure has to be, doesn't it?
Absolutely. Miss a step and it can all go sideways. So the case had to go back down to the district court. And just to keep track of the lawyers here for that first procedural round, the Crown had Noman and Gouda, and Belghar had Newton.
Right. So back in the district court, the crucial next step happens on March 8, 2012. Belghar is formally arraigned on the amended indictment. Charges read out. He enters his plea, presumably not guilty at this point to the big ones, setting up a trial. He was facing 4 counts then. Attempted murder.
The alternative, attempt GBH with intent.
Intimidation is another alternative.
And assault occasioning actual bodily harm.
Right. So now the decks are clear procedurally. Belghar, still with counsel G.A. Newton from Legal Aid, makes the application again for a judge-alone trial, before Judge Solomon this time.
And his argument was specific. He said, essentially, I have a genuine fear I won't get a fair trial from a jury. Why? Because of his religious or cultural basis relating to his attitudes towards Canaan, and because of, as he saw it, adverse publicity regarding persons who hold extreme Muslim faith beliefs. He felt a jury might be unfairly swayed against him because of all that.
The Crown lawyers, Noman and Gouda, opposed it. They argued correctly, look, the onus is on Belghar. He has to convince the judge why it's in the interests of justice to ditch the jury for this case.
But Judge Solomon was convinced. He granted the application. His reasons, as we noted, were later described as informal and shortly stated, but he found Belghar's fear, his apprehension, was reasonable.
And this is the bit that really became contentious later, wasn't it? His reasoning seemed to suggest the Crown hadn't shown any prejudice against having a judge-alone trial. He contrasted it with cases about general attitudes, saying here, there is direct reference to aspects of the Muslim faith which may cause a jury to take their mind off the central issue, which was intent.
Yeah, he basically seemed to say, the Crown hasn't shown me why we shouldn't have a judge-alone trial. And interestingly, the record notes the Crown prosecutor at the hearing expressly acknowledged that he did not require the trial judge to give further reasons.
Which might suggest they thought, okay, we've got enough here to appeal this successfully.
Quite possibly, because those very points, the feeling the judge flipped the burden of proof, accepting subjective fears without much solid evidence, the brief explanation they formed, the core of the Crown's appeal. They weren't happy.
So the battle for the bench moves up a level. Act 2, Part 2. The appellate crucible. The Crown appeals Judge Solomon's decision straight to the NSW Court of Criminal Appeal. This is the big one. R.V. Belghar, NSWCCA 86.
And the legal teams are the same for this showdown. Noman Gouda for the Crown, arguing against the judge-alone trial.
And G.A. Newton for Belghar, defending Judge Solomon's order, arguing it was the right call for his client.
The Crown really went after Judge Solomon's reasoning. They argued he gave undue weight to Belghar's subjective fear. Where was the concrete evidence? They pointed to another case, Arthur's, which asks if these fears are just fanciful or irrational.
They also pushed back hard on the idea that juries couldn't be fair. They highlighted all the safeguards, random selection, lawyers challenging jurors, judges giving directions. They said there was simply no evidence to suggest that a jury is likely to be drawn from people who harbor anti-Muslim sentiment.
And they argued, look, even if jurors had views on strict beliefs, the real legal question was Belghar's intent. You figure that out from his actions. A judge can direct the jury. Focus on the actions, not potential prejudice based on religion. Plus, Belghar himself didn't say in his police interview, my faith made me do it. And, outdated attitudes towards women aren't exclusive to any one group.
But their killer point, legally speaking, was procedural, wasn't it? That Judge Solomon got the onus wrong.
Exactly. They hammered that home. The law requires the applicant Belghar to show why a judge-alone trial serves the interests of justice. It doesn't require the Crown to show why it would be bad. Solomon seemed to flip that, they argued.
Okay, so how did Belghar's team respond? How did they defend the judge-alone order?
Well, they drew on that same Arthur's case, arguing the accused person's own preference should carry weight. They also pointed out, quite reasonably, that judges give written reasons for their verdicts. Juries don't. That transparency helps if there's an appeal later.
Makes sense. Do they mention efficiency? Sometimes that comes up.
Briefly, they referenced another case, Marcoux, suggesting maybe a judge trial would be quicker or simpler. But that's usually not a strong argument on its own. Their main point was that real prejudice would happen. Belghar's admitted attitudes, his views about his wife and the beach, even if not the sole cause, could taint the jury's view of his actions despite any directions.
And they argued intent wasn't really about objective community standards.
Right. They said things like reasonableness or indecency, maybe those need a jury's community perspective. But intent, That's something a judge is perfectly equipped to decide. So judge alone was suitable here.
So the arguments are laid out. How did the NSWCCA, led by Chief Judge McClellan, rule? This is the judgment that became so important, right?
Absolutely foundational. McClellan really clarified Section 132. First big point. He said the law does not start with a formal presumption in favor of a jury trial that the applicant has to knock down. The starting point is neutral. The court just asks which way, judge or jury, best serves the interests of justice for this specific case.
Okay, so no initial hurdle favoring a jury. But there's always a but, isn't there?
Usually. Well, there's no presumption. McClellan was very clear. The person applying for the judge-alone trial carries an evidentiary onus. You can't just ask. You have to bring something to the table. Evidence, material, arguments that show why a judge-alone trial is actually needed for your case.
And what did you think of Judge Solomon's decision?
He found significant errors. Said Solomon didn't really have enough evidence backing up Belghar's fears. It was mostly just the lawyer's submission. Solomon also failed to properly weigh up whether jury safeguards like judicial warnings could manage the potential prejudice. And yes, McClellan confirmed Solomon did get the onus wrong. The burden was on Belghar, not the Crown.
What about the point that judges give reasons? Did McClellan agree that was important?
He acknowledged it, yeah. So the transparency of a reasoned judgment compared to a jury's black box verdict is relevant. It helps with appeals, but he stressed it was but one factor, not the deciding one.
And the other two judges, Hidden and Hislop, they agreed with the result.
They did. Agreed Solomon's order had to be quashed due to the errors, but they had slightly different nuances in their reasoning. Hidden J, for example, wasn't keen on even talking about presumptions or onus. Both were maybe a bit more cautious about how much weight things like efficiency or reasoned judgments should get, seeing them perhaps as policy for Parliament. It just shows the complexity even among the judges.
But the overall message from the NSWCCA was pretty clear, wasn't it?
Crystal clear. If you want a judge-alone trial because you fear bias, you need more than just a feeling. You need evidence. You need rational justification. The court trusts juries, trusts judicial directions. Unproven fears aren't enough to ditch the jury system.
So the outcome was?
Crown's appeal upheld. Judge Solomon's order for a judge-alone trial quashed, overturned. For those serious charges, attempted murder, attempt GBH Ismail Belghar was going back to the district court. And he was facing a jury.
Which brings us to the final act for Belghar in these proceedings, the denouement. The NSWCCA rules on May 4th, 2012, decisive loss on the judge-alone front. Jury trial it is for the big charges.
And then something quite dramatic happens. It really underscores the impact of that ruling. The very next time his case is listed in court, just 4 days later, May 8th, 2012.
What happened?
Ismail Belghar pleaded guilty, but not to attempted murder. He pleaded guilty to 2 significantly lesser offenses that were on the indictment.
Which ones?
Count 2, which was detaining Kanan without consent to intimidate her. Still serious, max 14 years. And Count 3, common assault, max 2 years, served concurrently.
And the Crown accepted those pleas?
Accepted them in full satisfaction of the indictment, meaning they dropped the original top charges, attempted murder, attempt GBH, gone.
Wow. The timing is incredible. It really suggests that losing the judge-alone fight, facing a jury on attempted murder, was the tipping point, doesn't it?
It seems almost certain, yeah. A major factor, maybe the deciding factor, in pleading guilty to the lesser charges instead of rolling the dice with the jury on the much heavier ones.
So sentencing. That happened later, October 19, 2012, before Judge Zara. What sentence did he get?
For the main charge, detaining for intimidation, he got 4 years and 6 months imprisonment. With a non-parole period, the minimum time he had to serve of 2 years and 6 months. The common assault sentence ran concurrently.
And what did Judge Zara say about the seriousness of the crime itself? Objectively.
He found it was of a most serious kind. Said Belghar's intent was clearly to put Kanan in fear of her life, to assert his authority, control his wife. The victim felt extreme terror. Even though it might have been impulsive, it had to be seen against that background of the earlier threats.
And the fact it happened in public.
Yeah, Judge Zalin noted that. Attempting to control family relationships violently, in public, near children, showing disregard. He specifically found Kanan believed she was about to die and that Belghar intended to create that terror by holding her over the railing.
What about Belghar's personal circumstances, his background, mental health?
Judge Zara considered all that. His age, Moroccan background, the anxiety, depression, social phobia, being on the pension. But he also noted a psych report said these issues weren't the underlying cause of the offending, and he wasn't impaired at the time.
Did the judge think Belghar showed remorse?
He found Belghar minimized his actions, lacked real insight or remorse, except maybe secondhand remorse expressed to others, so he didn't give much weight to those expressions. He did give a 10% discount for the guilty plea, though the utilitarian value.
And you mentioned special circumstances.
Yes, under Section 442 of the Sentencing Act. Because of Belghar's ongoing mental health needs, Judge Zara found special circumstances applied. This meant he wasn't considered an appropriate vehicle for the full weight of general deterrence, which usually translates to a slightly shorter non-parole period relative to the total sentence.
But even that wasn't quite the end of the road legally, was it? Belghar appealed the sentence itself.
He did. Sought leave to appeal the sentence for the kidnapping count, arguing it was manifestly excessive, basically. Way too harsh compared to similar cases. That appeal was Belghar v. R. NSWCCA 245.
And new lawyers for that appeal.
Yep. Yeah. Belghar had Miss A. Francis and Emma C. Wasley from Legal Aid. The Crown had Miss S. Herbert.
And the outcome of the Senate's appeal.
The NSWCCA panel, Gleason J.A., R.A. Holm J., Adamson J., heard it on October 31st, 2013. They granted leave, meaning they agreed to consider it, but ultimately dismissed the appeal. The sentence stood.
Why did they dismiss it? Did they disagree with Judge Zara's assessment?
No, they largely upheld it. Agreed with his view of the objective seriousness, extreme intimidation, victim feared for her life. They said the judge didn't necessarily have to slot the crime into a precise seriousness category for the specific offense anyway, and they looked at the comparison cases Belghar's team raised and said, nah, these are different, often because of the offender's mental state at the time of the crime or other key factual differences.
So while his background and mental health were considered, the core focus at sentencing and on appeal remained the severity of the violence and the perceived lack of real remorse.
Pretty much, yeah. The objective gravity of holding someone over a 4-story drop, intending to terrify them, that weighed very heavily.
Okay, so let's zoom out. Beyond Belghar himself, what's the lasting impact? Why is R.V. Belghar NSWCCA 86 considered such a big deal?
Because it became what lawyers call a seminal judgment. It really defined the modern approach to judge-alone trial applications in NSW, and its ripples were felt across Australia. It gave teeth, practical meaning, to those 2011 law changes that took away the Crown's veto power.
Right. Before Belghar, even with the law change, there might have been this lingering idea that juries were still the default you had to argue strongly against.
Exactly. And Belghar's first big legacy point from Chief Judge McClellan was killing off that idea of a formal presumption for a jury trial. He said the starting point is neutral. What do the interests of justice require here, judge or jury?
But the crucial balance? It didn't make judge-alone trials automatic either.
Not at all. That's the second key principle. The applicant has an evidentiary onus. You have to bring something real to the table. Evidence, solid arguments, reasons why a judge-alone trial is actually needed for this specific case.
And it has to be about this case, not just general ideas.
Precisely. General arguments about efficiency usually don't cut it, though the specific length or complexity of the trial can be relevant because of the burden it might place on jurors.
And what about the accused's own fear, Belghar's core argument?
Relevant, yes, but not decisive. Belghar made it clear. The fear needs to be rationally justified and supported by evidence, not just fanciful or unsubstantiated assertions. Simply saying, I'm scared of biases isn't enough.
And the objective community standards point.
That's still relevant under Section 132. If a case turns on things like reasonableness or indecency, things where community view is valuable, that might lean towards keeping a jury. Although Belghar itself found intent wasn't necessarily one of those things in that specific context, it's still a factor judges weigh up.
And this case gets cited a lot now.
All the time. In later NSW cases on judge-alone trials like R.V. Villalon, Alameddine VR, it's in the bench books for judges, legal guides for practitioners. Standard stuff.
And its influence went beyond NSW.
Definitely. Discussing comparisons between states, even informed temporary laws like Victoria's COVID-related judge-alone trial provisions. It set a benchmark.
And this all happened while, generally speaking, judge-alone trials were becoming more common anyway, according to the stats.
Yeah, BOCR's data shows that trend. So Belghar provided this crucial legal framework right as the practice was evolving.
So when you put it all together, Belghar did this really important balancing act, didn't it?
Perfectly put. It removed a conceptual hurdle, getting rid of the presumption idea, making judge-alone trials feel more accessible in principle. But at the same time, it slammed the door on them being granted easily or uncritically. It demanded real justification based on evidence for that specific case.
It defined the path, The door's open,
Darn it.
but you have to make a compelling, rational case to walk through it.
Exactly. A bar that, for the original serious charges, the NSWCCA decided Ismail Belghar hadn't met.
So the Belghar case, starting in that ordinary shopping center car park, ending up as this landmark decision, it really highlights that ongoing tension in the justice system, doesn't it?
It really does. How do you weigh one person's genuine fear of prejudice against society's commitment to trial by jury by the community?
And the judgment's message seems to be, we hear your fears, they matter, but they need some substance. They need to be weighed against the protections we already have in place, like judges directing juries properly.
It's also perhaps a pragmatic recognition, isn't it? That in our complex world, sometimes maybe in very specific, carefully justified situations, an alternative way of running a trial might actually be fairer.
The legacy is clear then. Belghar drew the map for getting a judge-alone trial in NSW. It's possible, but you need to show why the interests of justice demand it in your unique situation.
And that leaves you, the listener, with something to mull over, perhaps. The law now accepts that fear of prejudice can potentially justify avoiding a jury. But what level of proof, what kind of evidence would you need to see to be convinced that such a fear is truly reasonable and strong enough to outweigh that fundamental principle of being judged by your peers? Where does that balance really lie for you?